Hello, everyone. Welcome. We will get started in just 1 minute. Give everyone a chance to get on. All right. Welcome, everyone. Thank you for joining us today for our event called Equal Pay for People with Disabilities, the Minnesota Disability Law Center's report on ending the subminimum wage in Minnesota. My name is Marin Holden. I use she, her pronouns, and I'm a supervising attorney at the Minnesota Disability Law Center. I'm a white woman with blonde hair and glasses, and a plant and some random wall hangings behind me. I'm in my basement. Before we get started, I just want to do a little bit of welcome and housekeeping. We do have closed captioning and an ASL interpreter for this event. To use the closed captioning, there are 2 ways to use it. One is at the bottom of your Zoom screen, there should be an option for captioning or CC. And if you hit that, it should pop them up. Also, Susan just put in the chat a link to an external website that also will contain the captioning, and there will be a full report transcript of the event afterwards. Our ASL interpreter should be spotlit already on the screen. So hopefully you can see Sam, but please feel free to message me or Susan or any of the other co-hosts if you have problems with either the captioning or ASL. We will have time at the end for questions or feedback. And if you have questions that come up while we're presenting, you can please put them in the chat, and someone will be monitoring the chat. If they can respond to your question right away, they will. Otherwise, they'll keep them, and we'll kind of look at all the questions that we've got at the end. If chat is not accessible to you, you can please raise your hand at some point, and we'll try to get to you once it's time, but during the question time at the end. We ask that you keep your mics off unless you're speaking, so that can help make it easier for everyone to hear. And it's up to you whether your video is on. These slides we will make available afterwards. And if you need, it will be a PDF, but if you need a screen reader friendly version of the slides, please email Susan Florent, who will put her email address in the chat, and we'll make sure that you get a screen reader version of the slides. There are 4 of us from the Disability Law Center who are going to be presenting today, and I want to give my colleagues the chance to introduce themselves. So I'm going to first turn to Jonah, then Delane, then Susan, and to introduce yourselves.
Hi, y'all. My name is Jonah Giese. I use he, him pronouns. I'm a white man. I have short cropped hair, rosy cheeks, and 2 golden earrings in my ears. I'm excited to be with y'all today.
My name is Delane Remish. I'm a legal advocate in the Mankato Disability Law Center office, and I am a white woman with glasses and brown hair, and I'm in my orange home office today. So thanks for coming.
Hi all, my name is Susan Florent, and I'm an Equal Justice Works Fellow and attorney at the Disability Law Center. I'm a white woman wearing a green sweater with long, straight brown hair. My background is a blurred white background, and my pronouns are she, her.
Thanks, everyone. Next slide. So I'm going to go to the next slide, Jonah, if that's
Yeah,
possible.
having difficulties. One moment. There we
No
go.
worries. That was quick. So our plan for today is, first, I'll just do a brief introduction of the Minnesota Disability Law Center. Then we'll move into kind of our presentation about our report. And I'll start with a brief overview of kind of why we decided to do it and what questions we were trying to ask. And then our team will present on kind of 3 of the major sections of the report: the history of subminimum wages, Minnesota context, what has happened in other states, and then we'll also talk about some of the policy recommendations and what's next, and then we'll have time for discussion and questions. So the Minnesota Disability Law Center, we are Minnesota's protection and advocacy agency for people who have disabilities in Minnesota. That means that we receive federal funds to do this work. Every state has a protection and advocacy agency. Here at our Minnesota Protection and Advocacy, we are part of Mid-Minnesota Legal Aid, which is a legal services organization. And some of our responsibilities as we call it, P&A, which is short for Protection and Advocacy, include legal support, which means we can provide free legal services to kids and adults who have disabilities. We can monitor facilities, do individual case advocacy and policy advocacy, and we also do some reviews for representative payees. Our services are statewide. We are a statewide organization. And again, we have what we call access authority in addition to our individual advocacy, which allows us to do monitoring, investigations, and policy advocacy in addition to free legal services. We have, as many organizations during the pandemic, we've been through times of change, and we're very excited to have a new legal director who started with us in late August of 2022, and she's with us today. So I want to turn it over to Jen quickly to give her a chance to introduce herself to you all.
Thanks, Maureen. My name is Jen Purrington. I use she, her pronouns. I'm a white woman with brown curly hair, and I am in a white basement, so the background is pretty white. I am just here to say I'm so excited to be part of this organization. I came from the Colorado Protection and Advocacy Agency. We moved to Minnesota in 2020, and I'm just looking forward to hearing from the group today, and thanks for being here, everyone.
Thanks, Jen. So we'll put this up here now, and we can put it up again at the end, but we do want to make sure everyone has our contact information in case you do ever want to reach out for our client intake line or visit our website. So turning now to our work in examining the subminimum wage. As you know, it's our responsibility. This is what we are designated to do in our state, to represent and protect the rights of people who have disabilities. And so back in 2017, which is, I used to say that was 5 years ago, but now that's actually 6 years ago, we did a data request to the government about data on people who are being paid subminimum wage in Minnesota. And that gave rise to a lot of questions. And so what we did then after that is we started to really just go out. We wanted to go out and see what a lot of where people were working and where people who are being paid subminimum wage, how that was going. And so we did an extensive number of monitoring visits to different places across the state. And that was really instructive to see kind of the full range of some people, some places were really continuing to use subminimum wage. Some places were starting to move away from it. In around 2020 and in 2021, in that 2021 legislative session, the legislature created what's called the Task Force on Ending the Subminimum Wage, which was tasked with not actually ending subminimum wage, but developing a plan for if subminimum wage were to end in Minnesota, what would be recommendations about how to do that, how to support people, how to support employers, how to support families to make that transition. And during that time, we were also working on our report because as the P&A, we have relationships with lots of other states who are doing similar work. And so we really wanted to find out just a little bit more about what has been involved in ending subminimum wage or phasing it out in other places, and what that could look like for us. So that's a little bit of the timeline. So as you can see, this report is the culmination of years of work, and the four of us here are presenting now are the ones who are currently at DLC working on this. We're four of the people who are. There are others too. But there have been many people who have come before us who are in different roles. And so this has really been a group effort. And we're grateful too for the many partners who have, partnered with us on this. We really wanted to kind of highlight why we did this. Like, why did we decide to do a report on this? And what did we set out to address? And so here are some of the questions that we hoped to address in our report and why we thought it was important to spend so much time looking into this issue. So first is, what is or has been the impact of subminimum wage in Minnesota, and certainly now? For other states that have begun to phase it out or who have phased out the use of subminimum wage, how did that go? What happened in those states? What was the impact on people who had been paid subminimum wage? How did that impact employment access for others who have disabilities in the state? And then finally, if subminimum wage were to be phased out in Minnesota, how would that impact people who are currently working in subminimum wage jobs? Because we obviously, want everybody to have the chance to make choices about where they work and how they spend their time. And so that includes people who are currently working in subminimum wage jobs. We published the report in October of 2022. And are really happy to have this chance and super grateful that you all are deciding to spend your Friday afternoon with us talking about it. So this is just kind of the key sections of the report on ending subminimum wage. And we will go into some of these in more detail, but at the beginning, there's an executive summary overview. Then there is a glossary and key terms. And I just want to share some of those key terms with us so that when we use them throughout this presentation, they're not surprising to you. So the report uses the phrase community job, which is commonly referred to as competitive integrated employment. But a community job refers to an employment arrangement where a person who has disabilities is employed in an integrated setting alongside workers without disabilities and is being paid at least a minimum wage. We like the phrase community job because it's more plain language, and it also clarifies that sometimes these employment rate arrangements aren't necessarily competitive. That can carry a lot of meanings in terms of like a competitive application process or something like that. Then we also use the phrase in the report sheltered workshop. Sheltered workshop is a colloquial term. It's used to describe settings where people who have disabilities are separate, with not necessarily working alongside people who don't have disabilities, and that employs people with disabilities. And these are often places where you find people who are being paid subminimum wages. And then finally, subminimum wage, another key term, is a wage being paid to a person with disabilities that's below the federal or state mandated minimum wage. So some of the next sections of the report are the history of subminimum wage, the Minnesota context, a review of other states, and policy recommendations. And I am excited to turn it over to Jonah to talk about the history of subminimum wage.
Thank you, Martin. So, sorry, I guess I have to do having difficulties with. Wonderful. Okay, so to begin our review of the history or subminimum wage generally, we really wanted to go back to where it all started. We wanted to know what the original intent was and how the institution came into being. So in 1938, Congress passed the Fair Labor Standards Act. The Fair Labor Standards Act was part of Franklin Delano Roosevelt's New Deal legislation. And it did a lot of good things. For the first time, it set a cap on how many hours a week a worker could work. It also set a minimum wage for the first time in this country, but it also carved out some important exceptions. And really the exception that we're here to talk about today is Section 14C. Section 14C authorized payment of subminimum wages to people with disabilities on what's called a piece rate wage. it meant that employers could apply to the Department of Labor to get this particular certificate, a 14C certificate, and then pay workers with disabilities a subminimum wage. You know, the original intentions of this may have been good. Some evidence or some research suggests that the original legislative intent of this was to provide people returning from World War I who were disabled and in combat a training wage to then move on to competitive integrated employment. But in either case, after this happened in 1938, 14C exploded, sheltered workshops exploded, and across the country, thousands of sheltered workshops opened their doors for the first time. It's also really important to understand our particular localized history of subminimum wage. Based on our archival research, the first sheltered workshops in Minnesota were established in the Twin Cities around 1910, 1914. Of course, at the time, 14C had not been established, but sheltered work where people with disabilities were separate from the workforce were in full force at this time. Around that same time, in 1919, vocational rehabilitation, the first vocational rehabilitation agency opened in Minnesota. And this agency, they supported sheltered work, but they also supported short-term vocational centers, which had the goal of getting people with disabilities jobs in a much shorter timeline. So during like the mid 20th century, vocational rehabilitation agencies supported mostly these short-term trainings. And it wasn't until the 1960s that sheltered work as we understand it today with subminimum wage in a segregated setting exploded. In 1965, the Minnesota legislature passed the Long-Term Sheltered Work Act. So in 1965, this was passed and allowed local jurisdictions to raise taxes, raise tax levies, and allowed local jurisdictions to open their own sheltered workshops. And so across Minnesota, more and more 14C employers began to open their doors. And they use federal, state, and local funds to do this. I think it's also important to point out that the history of deinstitutionalization in the latter half of the 20th century really impacted the expansion of sheltered work. Walsh v. Levine, which, if I'm not mistaken, the Minnesota Disability Law Center was a party to, and led to the deinstitutionalization of a state facility. As part of the settlement, it created more placements for people in sheltered work, and it led to a further expansion of sheltered workshops in Minnesota. And as you can see, the numbers bear this out. In 1965, only 700 individuals worked on a subminimum wage. By 1990, 5,600, there's a number that's wrong there. 5,600 and I think 86 worked in sheltered works. Please note that number on the bottom is wrong. And as sheltered work expanded in the latter half of the 20th century, criticism really started to emerge from self-advocates, from disability rights advocates and organizations, and from the legislature. One of the most interesting things that we pulled up from our research was that in 1981, there was actually an attempt by self-advocates, by people working in subminimum wage, to unionize their subminimum wage employers in Minnetonka, Minnesota. It was an unsuccessful attempt ultimately, but I think it highlights how for a long time, self-advocates have been trying to advocate for themselves and fight the conditions of employment at subminimum wage employers. In 1984, the Office of the Legislative Auditor also began to look at the practice. In their report, they say that the subminimum wage program is not meeting the goals to rehabilitate workers. Again, talking about the original legislative intent, how it's failing to live up to those vaunted goals. In that report, they also say that only 2.8% of workers transitioned to community jobs, showing that most people who entered sheltered work stayed in sheltered work for the majority of their working lives. And since then, people have looked at it, self-advocates have raised issues with it, and there have been some moves towards reform, but they've not been like a comprehensive systemic change to subminimum wage employment. In Minnesota, we like to do pilot projects and start task forces, but there have been no further legislative action. And instead, we've actually continued to fund and expand funding for sheltered work in that time. And that's what leads us to the present day. As you can see, in 2018, Minnesota spent $239 million on sheltered work funding and 10 times less, only 20 million, on employment services for people working community jobs. And in Minnesota, only 5.1% of disability-related funding goes towards employment services supporting community jobs. Nationwide, that percentage is 11.6%. And so, yeah, we put a lot of money towards sheltered work, and we really don't prioritize funding employment services for people in community jobs. This graphic really highlights that stark disparity. So the annual funding, this graph is titled "Annual Funding for Integrated Employment has lagged behind annual funding for facility-based employment." In the time period shown in this graph from 2015 to 2018, state-based funding for integrated employment is much less than state-based funding for facility-based employment by hundreds of millions of dollars. I want to note that the report only assesses data from up to 2018 because that's what was available from many of the data sources that were available. Since we finalized the report, some data has come out that this disparity has shifted, and Minnesota has put some more money towards facility-based employment, or I'm sorry, towards integrated employment and community jobs. But when we last looked at the data in 2018, obviously there's a stark difference. And so what does that mean for people who are working in subminimum wage employers from day to day? In Minnesota, 73 employers are authorized to pay subminimum wages. That means that 73 employers have applied to the Department of Labor to get a 14C certificate. It means that they have to apply, I think, every 2 or 3 years. And from there, they can pay people subminimum wages based on how productive they are with piece rate wages. If you go to one of these employers, I've gone to many just during monitoring visits, you go and you meet with people, talk with people, and far too often you notice that only a couple types of work are offered to people who work at these locations. Cleaning, recycling, light assembly are often the only jobs that are often offered to folks who work in subminimum wage employment. There are some subminimum wage employers who do a great job to offer opportunities to work at satellite locations in semi-integrated settings, but far too often we see the same paradigm where only 1 or 2 types of work are offered. I also want to note that often, though not always, subminimum wage workers work in segregated settings. I say not always because there are cases where people who earn subminimum wage are working in satellite locations in an integrated manner. And this paradigm, it really impacts a lot of people. According to data released by the Department of Labor, 3,744 individuals in Minnesota are paid a subminimum wage. This number, in my opinion, is not a reliable count. It, I think, systematically undercounts how many people who earn subminimum wages in Minnesota. This is the number that's reported by subminimum wage employers when they annually, or every 2 years, apply for a 14C certificate. State agencies in Minnesota estimate that between 4,500 and 6,000 individuals actually earn subminimum wage. The average subminimum wage worker earns less than $4 per hour in Minnesota. And all of this data is coming from the Freedom of Information Act request that Mara mentioned earlier. In some cases, as little as 7 cents per hour. And the average subminimum wage worker works fewer than 10 hours a week. So if you think about that, working on average 10 hours a week for only $4 per hour, you get your paycheck every 2 weeks. That's only $80. As many of us in this Zoom know, the federal minimum wage is not a living wage to begin with. And now imagine earning only $4 rather than $7.25 per hour. And what happens? This contributes to high rates of poverty for people with disabilities, and it's an enormous problem. All of this that we're talking about is even more upsetting when you consider Minnesota in comparison to other states. We have the third most people working in subminimum wage jobs compared to all other states. The only states that employ more people on subminimum wages are California and Pennsylvania. And as we know, California and Pennsylvania have far more people. So on a per capita basis, we employ a lot of people working subminimum wage jobs. Nationwide, 12% of people with disabilities worked in subminimum wage settings in 2018, while 44% of Minnesotans with disabilities earned subminimum wage jobs. That's a really alarming statistic comparing ourselves to the rest of the nation. Nationwide, 21.1% of people with disabilities worked in an integrated setting in 2018. In Minnesota, only 11% of Minnesotans with disabilities worked in integrated settings. And so with all of this in mind, we saw that Minnesota is falling behind. And we as the PNA decided that we wanted to address this and start looking at what other states were doing to see if we could fix the problem, to see if we could offer recommendations to the state. And so we did. And with that, I'll turn it to Susan to talk about how other states have worked on the issue.
Thanks, Jonah. Hi, all. This is Susan again. We'll hop to the next slide, and it'll show that there are currently 8 states that pay all people.
I'm having difficulties. Give me one moment.
Okay.
There we go.
Thanks, Jonah. There are currently 8 states that pay all people with disabilities at least the minimum wage. And those states are Alaska, Hawaii, Maine, Maryland, New Hampshire, Rhode Island, Vermont, Tennessee, and then also the District of Columbia. And at least 5 states are in the process of currently phasing out subminimum wages with a set end date. Those are California, Colorado, Delaware, Oregon, and Washington. Additionally, 2 states, Illinois and Texas, prohibit the payment of subminimum wages in contracts with the state. And there have been different approaches to these states that have ended or are currently phasing out subminimum wages. Some have taken administrative rule changes approaches, others have taken legislative action, and there's been litigation in a state that we'll also discuss. And so I share these experiences of the other states to share takeaways that we used to inform our recommendations, which we will share after I share about these states. So we'll first start with Vermont. Vermont has long been a leader in providing integrated employment with equal wages for individuals with disabilities. Back in the 1980s, the state collaborated with researchers at the University of Vermont to start building out pilot programs to move people with disabilities into community jobs. And by 2000, the Vermont Developmental Disability Services Agency stopped funding new entrants into subminimum wage jobs at sheltered workshops. 2 years later, in 2002, Vermont began a 3-year phase out of Medicaid funding for sheltered work. And this closed both sheltered workshops and also enclave models of employment. By 2003, the last sheltered workshop in Vermont had closed. So it's been 20 years now since Vermont had that model of employment for individuals with disabilities. And a study of the workers from that final workshop that closed, of those, 80% found community jobs. and the remainder engaged in community-based non-work activities and other programming. This is an example of a change that happened through administrative action, through those rule changes at the Developmental Disability Services Agency rather than legislation. And fast forward to 2019, nearly 2 decades after Vermont started phasing out subminimum wages and shelter work, 49% of people with disabilities in Vermont worked in integrated community jobs. That's much higher than the national average of 21.5% of people with disabilities working in community jobs. The average wages in Vermont are about $22,300 per year for people with intellectual and developmental disabilities, which is much higher than what you would be making in a subminimum wage position. So what's a main takeaway from Vermont? Vermont tracked aggregate data, but not individual data on outcomes during the transition. So you'll hear in our recommendations how we are suggesting how to track data and really track outcomes, in maybe a bit more granular way than Vermont did. But overall, good outcomes in Vermont and an early leader in this work. And then we'll move on to Vermont's nearby state, Maine. And so Maine's journey to phasing out subminimum wages began also in the early 2000s. Shortly after, there's a Supreme Court case called Olmsted, which was a Supreme Court case in 1999, in which the court held that people with disabilities have a right to live in the community and receive community services rather than spending time in segregated institutions. So as a result of that decision, the state of Maine created a work group in 2003, and the work group was tasked with upholding the integration mandate of the Americans with Disabilities Act, and particularly with a focus on employment settings. By 2008, after the work group had developed recommendations, the Maine Department of Health and Human Services ended the funding of segregated work through the state's home and community-based waiver system. The state in this process leveraged federal, state, and private grant funding to implement person-centered integrated employment options. And by 2013, Maine had only 13 employers authorized to pay a subminimum wage, which then decreased to 5 in 2015. And by 2017, there was only 1 employer with a 14C certificate. By the time that Maine passed a law ending the payment of subminimum wages in 2020, there were no employers authorized to pay subminimum wages in the state. So another administrative rule change approach that then led into a legislative approach. So what can we learn from Maine? There is still underemployment of Mainers with disabilities. So ensuring that there are opportunities for community employment and individualized employment options is really key to an effective transition. And next we'll move a bit south to Rhode Island. In 2014, 80% of people with intellectual and developmental disabilities in Rhode Island who were receiving employment and day services were placed in segregated sheltered workshops or facility-based day programs. And so the Department of Labor actually began to investigate abuses of subminimum wages in some of these individual sheltered workshops. In 2012, the Department of Labor then ordered one service provider to actually pay $300,000 in back pay to workers who were earning subminimum wages because of some violations of wage and hour laws that were happening there. The Department of Labor then asked the Department of Justice to broaden the scope of the investigation, and DOJ, the Department of Justice, began investigating whether Rhode Island had violated the Americans with Disabilities Act and Olmsted, the Supreme Court case that I mentioned earlier. The state and the Department of Justice then entered into a consent decree, a type of agreement between the parties, and the agreement acknowledged that the state had violated the Americans with Disabilities Act, the ADA, by failing to serve individuals with intellectual and developmental disabilities in integrated settings. The target date for compliance was 10 years, and so this was back in 2014, so the target date is 2024. Monitoring of the implementation of this consent decree has demonstrated that the state has not been meeting the targets for the number of people working in integrated settings or the number of hours that they're working in those community jobs. There have been challenges due to staffing shortages, turnover, And the federal court monitoring the implementation of this transition has ordered the state to take action to implement wage hikes, to implement incentive programs, to lead some targeted training to address these staffing shortages and challenges. The Department of Justice has alleged that the state has failed to ask the legislature for sufficient funding to implement what the court has mandated. And the failure to raise wages for staff, the failure to increase reimbursement rates or adequately fund transportation and technology needs of individuals follows from this lack of state funding for these, to implement this transition and these changes. The Department of Justice has threatened fines to the state of 1.5 million per month if they remain in non-compliance. In October of 2021, a corrective action plan was put in place to address these ongoing issues. So the takeaway from this is that the Department of Justice has acknowledged that the Americans with Disabilities Act and the Olmstead Supreme Court case require that states serve individuals with intellectual and developmental disabilities in integrated settings, including underemployment services. And Jonah, we can move to the next state. Oregon is an interesting case. In 2012, there's a case called Lane versus Brown, which is the first class action lawsuit in the nation to challenge a state-funded employment services system, including subminimum wage work, as a violation of the Americans with Disabilities Act. And Title II of the Americans with Disabilities Act requires that public entities provide services to individuals with disabilities in the most integrated settings that meet their needs. So that was the sort of the main place that this lawsuit started. And in 2013 and 2015, the governor of Oregon issued executive orders directing the Oregon Department of Human Services to adopt an integrated employment plan. Then in 2015, the Department of Justice reached a settlement agreement with the state in the Lane case, requiring Oregon to move individuals into community jobs and to provide employment services, including to transition-aged youth exiting school. In September of 2020, the state stopped funding sheltered workshop services. And in 2019, Oregon passed a law to phase out subminimum wages by this June of 2023, with phased in scheduled wage increases. In our report, you can see more visual depictions of settlement data tracking individuals in that Lane class action case. So if you're interested in digging into the data a bit more, it is there in the report. And so how did Oregon accomplish their phase out? The Department of Human Services in Oregon barred new enrollment for sheltered workshops, provided grants to incentivize sheltered workshops to change their service models. They found that rate structures for providers, individualized job placement programming, and supports really play a role in the transition away from subminimum wages. And finally, the last state that we took a deeper dive into in our report was Maryland. Maryland passed a law, the Ken Capone Equal Employment Act, in 2016 that began a 4-year phase out of subminimum wages. So 4 years later, by 2020, there were no subminimum wage employers in the state. Maryland tracked individual and aggregate outcomes throughout this time, found that participation in community jobs, wages both increased. The data from Maryland show that the individuals who left sheltered workshops did not see an increase in segregated non-work services. So that's to say individuals who were no longer working in subminimum wage sheltered workshop positions were not simply funneled into segregated day services or other programs. There was an increase in community-based non-work in addition to the community jobs increase. And this was because the Maryland Department of Disabilities implemented individualized employment programming. Because of this, there was an increase in the overall employment rate for all workers with disabilities in the state, not only those who had previously been employed in subminimum wage positions. So this focus on individualized employment programming and a shift away from subminimum wage and sheltered workshop models and toward individualized education or individualized employment programming and opportunities really supported the entire workforce. One gap in Maryland's approach was that the state did not collect any data accounting for hours worked. So there is a bit of a gap in understanding how many hours individuals are working in the community jobs. So there's not a clear data tracking whether people are working a few hours or working full time. So more granular data collection may help ensure that a transition to community jobs is actually providing meaningful integrated employment opportunities. But with that summary of those 5 states, and like I said, there is more data and more information in our report that you are welcome to dive into, but I will pass it over to Maren, who will talk through our recommendations, which has been developed from the history and the other states' research that we've shared.
Thank you so much, Susan. I think what I really appreciate about the work of this report, and as I said earlier, much of this has been done by a team, including there are many people in the room who worked on this during their time at DLC, is that these policy recommendations really are rooted in what we learned from other states. So you heard Susan mention a few things, that we observed that other states didn't do, or that when we talked to those states, they said, we wish we would have done this, or things that they did do that turned out to be really useful in helping to make sure that as the phase out occurred, that people who are working in subminimum wage jobs had access to choice and supports for opportunities to pursue. So we have 10 policy recommendations that I will not go into a ton of detail of, but want to make sure that we are clear about what those mean. So the first is to expand the information, options, and education provided by agencies to empower people who have disabilities to learn about supports to find a community job through individualized planning. One of the things about employment supports in our state is that there are really multiple state agencies that can offer different types of supports, whether that's education supports, human services supports, or employment supports through DEED. And so there has been improvements in those agencies working together, but it can still be really difficult for agencies to seamlessly work together, and for people who are trying to use different types of services to know which agency to go to for what. And so we think that those 3 agencies can really work together to make more information available and more accessibly and easily available to people to find those supports, and through an individualized planning approach. A second recommendation is about making sure that employment's financial resources, policy guidance, and technical assistance is provided to employment service providers transitioning towards helping people find community jobs. We think that we've heard so many concerns from folks in our communities across Minnesota that, I am a service provider and I pay subminimum wage now, and that's what I've done for a long time. And we don't know how it could work any differently. And so we really think that as a state, if we're going to move towards a phase out, which we want to do at DLC, that we need to make sure that there are adequate financial resources and policy guidance and assistance for providers to make that switch. There was some funding in 2021 along with the task force, but we think some ongoing support would be necessary. There was a report from the University of Minnesota's Institute for Community Integration and the University of Massachusetts on the Minnesota Technical Assistance Project, MNTAP, that includes a lot of recommendations. And so we think that that sort of support on an ongoing basis is really important. Next, we want to make sure, and you could see that this was one of the approaches from one of the other states, that people who are receiving waiver-based through their Medicaid home and community-based services, employment services, are not earning subminimum wage as part of that employment support service. We think that that is one way to help support providers who are receiving federal Medicaid funds to make sure that when they're providing employment support services, it's all aimed at getting people into minimum wages. As Jonah kind of mentioned, we've seen for a long time that sometimes things that are seen as a training wage that are intended to be temporary don't end up being temporary. And so it's really important to also, change the way that we use Medicaid to make sure that folks who are receiving services through Medicaid are having access to minimum wage jobs like people who don't have disabilities. Then fourth, we also want to make sure that our Medicaid and home and community-based services waiver employment services make sure that that service system fully supports and funds the individualized process of supporting people to find a community job based on their interests and strengths. So a person support team, including case managers, waiver employment service providers, and vocational rehabilitation counselors should really work together and spend the time to talk through what it would be like to work in the community, resolving potential barriers such as transportation, and providing benefits counseling. And this truly often is a very individualized process that should follow person-centered planning practices. And so we may need to have more training and support available for this kind of coordination from those different service systems. One of our recommendations is to pass legislation to phase out the payment of subminimum wages in Minnesota by a specific date with funding to implement the phase out. And we think that that phase out should be, appropriate to make sure that we have time to plan for all the things that we've talked about, so that people who are currently earning subminimum wages have the opportunity to find community jobs if they want. Providers have the opportunity to figure out how to change how they're operating so that they can continue to provide the services that they want to provide, and to continue to provide other services that may be appropriate. So that's one of, so our goal is to have time and funding so that we can have a seamless transition. One of the things you probably heard Susan talk about in other states is also the importance of data, and that we really want to be able to see what is happening to people who are in subminimum wage now, and who might, be moving on to other things, or other, whatever happens as we transition away from subminimum wage in a phased out way. So we think DHS and DEED, so the Department of Human Services and the Department of Economic Development, should design and implement data collection systems to track on an individual level, to track progress away from subminimum wage work. They already do collect some of this data, but we think that there's probably more that would be helpful, and it should include how much each individual earned and how many hours they worked in subminimum wage employment, how much they earned and how many hours they worked after moving to a community job, if the individual wants to work additional hours, and whether they found a job in their chosen field. And the data collection should also include demographic information, like racial and ethnic information, to look for any possible disparities in employment outcomes. And like in Oregon and Maryland, we think that data should be collected at least every 6 months so that we can periodically analyze those outcomes. Another recommendation, this shows up a lot, is to fund transportation. So especially if we're looking at people being in different spots, integrated community jobs, that might mean different and more unique sets of transportation needs. And so we think it's really important that people have ways to get to work. And so, Minneapolis has taken some steps forward with pilot projects. There's also Dakota County's Lyft ride sharing project that was funded by a DHS innovation grant. Washington County had some success allowing workers who have disabilities by getting the vouchers to work with Lyft. But we think DHS should move forward, including ride sharing as part of waiver services, and that additional creative projects like volunteer driver programs and collaboration with community or faith groups may be needed to make sure that everyone has access to transportation to get to their community jobs. So the next one is to create seamless collaboration between DEED's vocational rehabilitation program and school special education services. Right now, oftentimes young people who are, getting older in their school careers, they may or may not have some collaboration with vocational rehabilitation, but VR, vocational rehabilitation services, truly are and should be available to most students who are in the transition part of special education. And so we think that there's a lot more where that collaboration works well now gets to really good outcomes for young people. But we think that collaboration can look better more across the board and for more students. So we think that there are some specific changes that could help with this. So for example, school districts providing information about vocational rehabilitation services at every IEP meeting after students in special education turn 14, that requiring and making sure that this actually happens, that VR counselors attend IEP meetings at least 12 to 24 months before a student's expected completion of 12th grade. We also think, we want to make sure that schools are documenting the participation of the DEED vocational rehabilitation counselor in the IEP process, and that PREATS, the pre-employment transition services, should include training on safety in the community to help transition age youth prepare to work in the community. Another recommendation is to make sure that everyone has access to benefits counseling, so that people who want to work in community jobs, it can often be really confusing about how earned income might affect government benefits, and lots of different types of those benefits. And so trained benefits counselors are really important because there is a lot of misinformation about how working can impact government benefits. We're very fortunate here in Minnesota to have the Work Incentives Connection at Goodwill Easter Seals, and they provide a really helpful resource that they can do a benefits analysis. And recent efforts by DEED and DHS to increase the number of trained benefits counselor has been a positive step, but we think that probably more will even be necessary, and the chance for people to return for more in additional information if their hours change or if they get a raise. And then finally, we think it's really important to provide really high quality integrated day programming for people who choose not to work. There may be people who choose not to work. That is a choice that we think should be honored if that's someone's choice. And so we should ensure that high quality integrated day programming is available, that can provide an opportunity for people to have organized integrated social opportunities that some may not otherwise have had, or would allow people to remain connected to friends and coworkers from when they worked in a subminimum wage setting. And so that can really help maintain social relationships. In Vermont, for example, people who transition from earning subminimum wages to working community jobs continue to meet for lunch with their friends and coworkers that they met while working for subminimum wages. There's just a lot of ways to help people keep the social connections that are really valuable to them, even if they've chosen to pursue a community job. So what's next for recommendations? So in addition to, so these are our recommendations based on our learnings from other states, but there are other kind of people out there coming up with other recommendations. And so one of those entities is the Minnesota Task Force on Eliminating Subminimum Wages, which is tasked by the legislature with putting forward a report with recommendations that will be released on February 15th. Thanks, Susan, you just put those in the chat. And so those will contain a lot of recommendations. If you look at those, you may see some similarities with the recommendations from our report. So it'll be interesting to see what comes of those. There also the governor's budget proposal that it was just released in the past week or two includes several pieces related to phasing out the use of subminimum wage. And so the governor's proposal is actually to phase out the use of subminimum wage by 2028, which is a little different than what I expect from the task force on eliminating subminimum wages, and also includes a few other things, I think, about how waiver services work to facilitate that. So we are not the only, we don't get to decide what happens in this state. That is up to our elected officials, our legislature, and our governor. We as the PNA feel like it's really important for us to do our best work in researching what we think is an important topic, hearing from people and states that have already done this, and then sharing what we've learned from those conversations with the community. And so that's what we wanted to offer today. And so at this point in time, I think we are now in the discussion and questions. And so I think, thank you, everyone. There have been some great questions in the chat. Delane, do you want to just start with the questions that we've, and I also see a good discussion going in the chat, but we'll start with the questions that have been directed at us. It seems like there's also a little bit of back and forth between people.
Yeah, thanks. Sorry. I'm a paper user, so I'm printing some of these out. The first question was really specific to Vermont, but I think it adds to kind of some of the consistent collective questions about what happens to people. The first question was, what about the 51% of the folks in Vermont who can't or who weren't included in the integrated setting or in the community employment? So what about them? And I just want to add, there's kind of a theme here because that was our first question. But then our third question was, I want to know what will happen to those people who can't hold employment at minimum wage. What will happen to the DT&H workplace that will not be able to pay for minimum wage? I want to know what will happen to the people who can't work in minimum wage. So I think to start there and see if some of the team members could respond a little bit to that. We expected and anticipated this question and understand that some people have been very happy with their work at sheltered workshops for sub-minimum wage. So we were expecting this, and thank you for your questions.
Yeah, thank you, Delane. So I can give a start, and then Susan, Jonah, or Delane, if you want to add anything. So one of the things that we know about Vermont is that, one of the impacts of phasing out sub-minimum wage and supporting people to move into community jobs was that one of the researchers reported that 80% of the people who had been working in sub-minimum wage jobs found competitive employment in the community, and the remainder found community-based integrated non-work placements. And so that doesn't entirely answer your question, in part because not all people who have disabilities are employed at the outset anyway. And so that 51% might include people who weren't employed at all before the phase out of sub-minimum wage and continue to not work following that. And so I think what I think is really the relevant number is that of the people who were working in sub-minimum wage jobs before the phase out, 80% found community jobs, and the 20% found non-work placements. So my guess is that some people, chose to not pursue community jobs. And I'm not, I think that's part of why also we think it's so important to have individualized data, because what we know about Vermont is that 80% did find community jobs and 20% found community non-work placements. But we don't know exactly why, that breakdown between the who and what the individual stories are for the people in those percents. I think that's a pretty good outcome, and that, 80% were able to find community jobs. One thing that too, that we have heard a lot about, and our folks who've represented DLC on the task force have talked a lot about, is that the proposal here to phase out sub-minimum wage does not include, and the governor's budget doesn't include this, and I don't expect the task force recommendations to include this, does not inherently change the ability of providers to offer work settings like where sub-minimum wage has currently been the prevailing wage. And so for some providers, and there's one specifically, at least one who has done this, where they continue to provide that kind of sheltered workshop style of work setting, but simply found ways to raise the wages so that everybody who's working there makes at least minimum wage. And so what this is really focused on, our report and also these recommendations, is how we raise wages. And I think there are lots of ways to do that. That can include looking for community jobs, and that can also include trying to figure that out. And that's why we think it's so important. And I think that was our second recommendation, is to provide those financial resources and technical assistance for providers to figure out how to do it. And we know that many providers have across the state. Susan or Jonah, do you want to weigh in on that specific question about Vermont, or kind of the broader question?
I don't think so. I think you covered it, Maren.
Okay, we
What's
also,
Elaine?
oh, pardon?
I was just going to you for the next question from the chat. Thank you.
Well, yeah, and this one's kind of interesting. I understand there currently exists a certificate and exemption within the Federal Fair Labor Standards Act for subminimum wage. But where in Minnesota statute are these same employers exempted from the state of Minnesota minimum wage? I'm not sure. One of
gonna-
you can respond to that.
I will do my best, but if there's other people in the room who know this better, there are some federal laws that have what's called preemption, meaning that states can pass laws on the topic, but when it comes down to it, federal law is supreme and can preempt the field, basically. And so when the federal government says employers can seek a 14C certificate to be exempt from minimum wage requirements in the Fair Labor Standards Act, that likely preempts any state law. I'm not sure that we need to, we have some state statutes that kind of track that, I believe, but we don't need to change the federal law in order to effectuate a phase out. We just need to change whether our state allows employers to have a 14C certificate and use that exemption.
Okay.
Is that a helpful answer? I can't see folks.
Yeah, I hope so. I'm getting back to him. I have a kind of an interesting one here. Can you or someone from the team clarify how disability is defined for purposes of subminimum wage laws?
That's a great question. I can find it in the Fair Labor Standards Act right now, but maybe, Susan, do you want to look for that in the Fair Labor Standards Act while we go to the next question?
Yep, I can do that.
Okay, another good one is vocational rehabilitation currently doing any trainings with its employees to work with people who have cognitive disabilities. Their website and current system seems to only focus on people who have physical disabilities.
Great question. I see that Chris McVeigh is here and responded in the chat. Chris, if you are here, if you are still here and want to
I am here.
directly, you are welcome to.
Okay, thank you so much. Yes, I'm with Vocational Rehabilitation Services. I'm so pleased about this presentation and I was able to join today. Vocational Rehabilitation Services absolutely does serve individuals with intellectual disabilities or cognitive disabilities. We serve people with disabilities other than vision loss or deaf blindness. That is our sister agency, State Services for the Blind. Since we had federal legislation that went into effect in 2014, it was signed in 2014, VR, the Vocational Rehabilitation Program, has been given very specific direction by the federal government about like, hey, we need you to focus more on serving people with cognitive disabilities. We need you to focus more on people that are at risk of earning subminimum wage or in subminimum wage employment. The other thing that legislation required of us that we've really bumped up and beefed up over the last number of years is how we serve and support students. And those students, especially those that are at risk of earning subminimum wage when they graduate from school. We want to focus with those youth, those kids, that they have paid work experiences if possible before leaving high school. So since WIOA implemented, we have had those two big extra focuses on our program. We always know that the marketing materials that we have are always a work in progress. Thank you for that feedback about like, it seems like they're only serving people with physical disabilities. That's not the case. And just again, I'm really pleased to be part of the discussion and listening to what the feedback is. We're definitely part of the equation in helping anybody with a disability move forward with their competitive integrated employment goals. Thank you.
Thank you, Chris.
Yeah, thanks so much for that, Chris. It's really helpful to have that input. There's a few more questions about what if a place can't pay the minimum wage?
I mean, I
Yeah.
think that's part of exactly why we think that support and technical assistance is so important. I think that's one of the things about this moment for this issue is that we're in a moment where there is an epic workforce shortage and there are supply chain issues. And if providers have contracts with whoever it is that the workers are doing the work for, now is the time to renegotiate those, because work is valuable, whoever is doing it. And the fact that prices are rising in other areas means that there should be more. Now people's labor is in high demand of all types. And so we really do think that it's possible for providers to, and there are so many in Minnesota that have made that switch. And those that have not yet, we want there to be ample resources out there, whether it be financial resources, coaching resources, training resources, to really make that switch. And one of the things that we're fortunate is that because there are so many providers who have, they're, I think, very willing to lend their expertise and how they made that work for them. And that's also why we think that a planned phase out, so not doing it immediately, is so important, so that those providers have the time to do that.
Thank you. There's a question about why do we have to end subminimum wage? That's kind of a theme throughout. If it's worked for my son or daughter, if it works for our family, if we feel that our son or daughter cannot go to work for minimum wage, why do we have to end subminimum wage?
It's a great question. And I might add to it, because I've seen a few other similar questions in the chat in terms of like, who is going to hire folks and why can't people have the choice to make subminimum wage? And I think, there are lots of different answers to this set of questions. Maybe the most practical one is that, as you've seen from some of the other states, sometimes states are forced to end the use of subminimum wage and sheltered work through litigation. That hasn't yet happened in Minnesota. I don't have any information that could happen soon, but sometimes states are forced to make that switch, and we think it's really important to be planning for that. Another reason is that ending subminimum wage on a phased out basis, which is currently federal law, has been in a bipartisan supported federal bill that's been on the Hill for several years and come very close to passing. It was included and then removed from one of the COVID recovery bills in early 2021. And so we do think it's really important to be prepared, as this is on the horizon federally. So that's maybe the most practical answer. I think from the P&A's perspective, this is really a civil rights issue. And we really do believe that disability is a natural part of the human experience, and that all people who have disabilities have gifts to offer and should be given supports to kind of cultivate their own interests from a young age. And that's why we have so many school-related recommendations, and given choices about how and where to work. And that isn't just about people who have disabilities and their families and the providers making that change. It's also about how employers see people who have disabilities and how employers change what they think is valuable and have a more expansive and creative understanding about who and what gifts could really take their efforts further. And so it is a human rights issue in that regard, but it's also a civil rights issue. In the early 1900s, and this is going to bring out the law nerd in me, I apologize, but at one point it was the law in this country that workers could contract for anything that they wanted to, no matter how bad it was for them. Basically, there was a Supreme Court case about whether or not bakers in New York should be able to work as long of hours as they want, even though they were all getting lung cancer. And during the New Deal, when President Roosevelt advanced lots of New Deal legislation that created much of the world that we understand today, the Supreme Court changed its mind and said, you know what, like, there are some basic rights that people have that there is not a right to contract for something, no matter how badly it would hurt you, essentially, except for people who have disabilities. And so that was in the late 1930s. And we're now almost 80 years later. And we do really think that it's time. And Congress has acknowledged this since they started investing in vocational rehabilitation. In 1990, Congress said that people with disabilities should have the opportunity and all the supports that they need to work in competitive jobs. And so we think that it's time to include people who have disabilities in that civil rights protection that's afforded to everybody else. And then kind of on a more human level, we wouldn't be recommending this if we really didn't believe that it was possible in a post subminimum wage world here in Minnesota for everybody to have a way to spend their time and get meaning and value from their efforts, find belonging and success and agency over their days without using subminimum wage. And as we've said, that can look like lots of things. It can look like individualized community jobs. It can look like raising wages in current sheltered work. It can look like a set of really robust community supports during the day. It's just going to take all of the things that we've talked about as far as recommendations to figure that out on an individual basis. That was a long spiel, so I don't know if any of my team members want to jump in after that.
I think you hit the high points. I think the only other thing I would add is that we live in an ableist society, and obviously private employers will continue to operate along those like ableist understandings. And so subminimum wage, ending the subminimum wage isn't going to fix any of that immediately. And there's certainly a lot of work to be done. Our argument is that this is one thing that can address subminimum wage work in particular. And hopefully disability rights advocates, our office can, as we go forward, continue to work on like addressing the norms that make it difficult for individuals to find employment and find meaning as they'd like.
More questions for us, Delane?
Well, there's a lot of discussion and it becomes like many times with chats, please direct your questions to the presenters. I know there's a lot of back and forth in here. I did want to highlight that it looked like Bud Rosenfield put in the federal info regarding subminimum wage and disability. He added a link in here for people to look at and to click on. I think that
Susan, do you want to speak to the definition that you put in the chat?
Sure, just coming back on video here. I can read out the definition from the act, at least in part. So it reads, a worker with a disability for the purpose of this part, meaning the part of the act, means an individual whose earning or productive capacity is impaired by a physical or mental disability, including those relating to age or injury, for the work to be performed. Disabilities which may affect earning or productive capacity include blindness, mental illness, mental retardation, apologies for the use of that term, that's from the law, cerebral palsy, alcoholism, and drug addiction. The following, taken by themselves, are not considered disabilities for the purposes of this part: vocational, social, cultural, or educational disabilities, chronic unemployment, receipt of welfare benefits, non-attendance at school, juvenile delinquency, and correctional parole or probation. Further, a disability which may affect earning or productive capacity for one type of work may not affect such capacity for another. So that's the definition. And then like Delane said, Bud also posted some resources and links in the chat that further expand upon that.
Thanks, Susan. I see there's a question that just popped up about limitations on SSI payments and how it affects benefits. And that's a great question. I mean, and that's actually, you know, kind of, it's part of the reason that VR exists, right? To be able to support people who are currently eligible for Social Security and disability to find ways to make, to make money and to work in society. And yes, I see you, Chris. And that's part of why one of our recommendations is about expanding access to benefits counseling. And we work closely with the folks at the Work Incentives Connection at Goodwill Easter Seals, and the work they do is amazing. I've never met an organization quite like that, where probably the average time that someone has worked there is over 15 years. The people who work there know this stuff in and out. And so we really have this tremendous resource in our state to help people do that analysis of benefits counseling. I will say, just as a side note, that some of our partners and our legal aid folks who work at the Capitol have been working to kind of make those benefits more workable for people who work by like changing the premium schedule for Medicaid for people who have for people who are employed people who have disabilities. But, you know, so there may be even some other policy changes outside of our recommendations related to that, but that's absolutely why it will depend on the person. It will depend on their circumstances. And we think there should be adequate resources out there for everyone to be able to do that analysis. Chris, I saw you.
Yeah, just really quickly. I'm, again, a very strong proponent of benefits planning, benefits information, for people as well as their family members that are supporting that person. And we are very, along with our DHS partner, Department of Human Services, we've partnered together very closely, and it's now including Goodwill's Work Incentive Connection, creating a fabric of access to information, just-in-time information for people, starting when kids are still in high school, planning and understanding how benefits and work go together. And in many cases, that there's a pathway, absolutely, for people to work and to still receive their benefits. Also, that there are times where people will go off of their benefits based on the benefits planning and the coaching and supports that they've received, and kind of like setting a course. It's not a one and done. It's something that we would anticipate that starting students, adults might learn about and find out about access information about their benefits and work throughout their working life. And so I just also strong proponent and supporter VRS and SSB, and more access for people learning about benefits and work. Thank you.
Yeah, thanks, Chris. There was a comment in the chat about kind of noting the context of our current structure. And I just want to remind, one of the slides that Jonah shared earlier pointed out the amount of spending that we do as a state on facility-based employment versus spending that we do for, I think it's slide 13, for integrated employment. And it's about, I'm going to get the raw numbers wrong because I can't read that chart, but it's about 10 times as much. We spend about, what that must be, 20 million on employment services supporting community jobs, whereas we spend over 230 million on sheltered work funding. And so I think that we really do have an opportunity in our state to kind of shift our default and shift. I think that our investment does make a big difference in terms of what options are available to people. And that's why you see that number that, you know, we have a higher rate of people in subminimum wage work relative to other states, even more highly populated states. And nationwide, 21% of people who have disabilities worked in an integrated setting, whereas in Minnesota, that number was only 11%. And so I know we often like to think of ourselves as a state that like is doing well and a model for other states, but this is one area where we really are behind. And you know, we're excited that there is so much discussion on this topic because we think that we have the chance to change to make more investments so that people can find the jobs that they want. I see one more question in the chat. I feel like we have tried to answer this. It will really depend on the person. Some people right now, it's, you know, there's a consensus that they can't hold a community job, but with this right supports, that could change. And I'm not saying that's the case for someone in your life. I'm saying that's one possibility. Another possibility is remaining in the current workplace while that provider figures out how to raise the wages to pay minimum wage. Another possibility is to go to the same place and continue to receive day services supports, but not be receiving a subminimum wage. As we pointed out, many subminimum wages now are very, very small amounts of money. And so, you know, that we think that it's much more important it's important to really figure out what options are available. That's what happened in Vermont. That's our goal, is to not have providers go out of business. That's why we think there should be so much training and support, and we're fortified by the success that many have had. And you know, the report doesn't put out a specific minimum hours, you know, in terms of what proposed success would be. I think that would be a community conversation, but the kind of data that we're proposing to collect on an individual basis, I think would be really essential to being able to have a robust conversation about that. And I would just also add that, you know, we are a big state, and all of us bring our own experiences, and we don't expect everyone to agree with us. We think it's our job as the P&A to see to take steps to advocate on behalf of the rights of people who have disabilities. We don't take that responsibility lightly. And we also know that it's important to do our homework. And so that's why we spent so much time asking these questions, putting together this report, spending so much time looking at what other states have done, and then developing our recommendations for Minnesota based on what we learned about other states. And this is our research, and these are our conclusions, and we're really grateful for the chance to share them with you all. And it's okay if we don't agree, but we are really grateful that folks participated in the conversation and are here to engage, because obviously it's really important and near and dear to many of our hearts. Delane, did you want to jump in there?
Yeah, I just wanted to share 2 comments because I think it's relevant. One of them in the chat was, how about assuring that there's a continuum of supports like full day job coaching, or being allowed to work at a job with a few getting job coaching in the plan, the way those that need more intense supports can be successful. And I just really appreciated that comment. And if that's not happening, I think starting to develop a plan of what's needed and how to help an individual have more choices and more options for community employment. If the conversation starts now, and of course, we're working a lot with transition age youth, that's better. And then one final one is, Bud Rosenfield added, one problem with allowing subminimum wage is that it's based on the ability to measure the worker's productivity, which ends up meaning that the only jobs that many people with disabilities are offered are those jobs that can be measured. That really limits choice and opportunities. Think of all the jobs that exist where we don't measure productivity. And think of how little minimum wage itself is compared to what other jobs pay. There are many built-in inequities in our economic systems, but allowing subminimum wage is by definition sub-minimum wage, less than what we should be expecting at a minimum. And we just want equal access for people with disabilities to have at least minimum wage as any and all of us. And so the creative thinking of finding ways to develop supports, and I do think there are systems in place now, and those are and have been increasing to provide supports to people with disabilities to try to find community employment. That trend has already started in Minnesota, and I think that will just continue. So to kind of step back and look at what are possibilities is really the question we want to help families and individuals move forward with. So
thanks, Delane. Now is probably a good time to transition to our thank you and wrap up. So Delane will turn that over.
Yeah. Again, we just really want to thank everybody for attending and for participating. There's some really hard questions, and I understand, and we understand that change is hard. But we also know that it's coming, so we want to be prepared. And on this slide, we really ask people, if you can, please click on our Survey Monkey for our MDLC priorities. We're required by the federal government to have these priority surveys and get feedback from the community, from families, from individuals with disabilities and providers. So please take time. It's also in the chat to click on the survey. It takes about 2 minutes. It's pretty quick, but share your thoughts and let us know what you think is most important, because we are to be led by our communities and individuals receiving services and families. So please let us know what you think.
And I might we can hang out here for 30 seconds, a minute, while you all go fill out that survey. We would love that if you would do it right now, because we just really appreciate your engagement. And the fact that you all decided to spend this time with us today is just such a gift to us and such a testament to the importance of this issue however you see it. And so thank you very much. If there are things that would be helpful for follow-up, we've included here our email addresses. I will leave this up for a little bit while I talk through some time for you to either do your survey or write down our email addresses. But know that this is a really important issue for us as the Disability Law Center, and we really hope for continued conversation and engagement on it on all fronts. So I want to say a very big thank you to our partners at the ARC for helping us with the Zoom account. And thank you to everybody who worked on this report over the years. So there will not, unfortunately, be CEUs for this presentation. We really mostly know how to do the CLEs for lawyers. So if you have if there are things that you know how you would need in order to submit it for yourself, please feel free to get in touch with us. We can share any like those slides or any of those materials, and we will be emailing out the slides as a PDF to the participants afterwards. And if you would need that in a screen reader accessible version, please let us know and we can do that. And yes, thank you. We really do hope that it's clear, and we intend to continue to advocate for recommendations that will not allow anyone to be dropped off, that really considers and makes options available for everybody based on who they are and what they want to do and their choices.
Yeah, and I'll just encourage people, if you do have concerns and/or if you are not being provided options or the business closes and you don't have any options, you can call the Disability Law Center intake. And there may be some ways that we can advocate on your behalf, on behalf of the person with a disability, to make sure that the team is working towards choices and options. And hopefully community employment and/or day services, whatever the individual chooses is best for them.
Yeah, thanks, Delane. One more quick note is that we did record this session. You probably had to click through consent for that at the beginning. So we can send that out with the follow-up, and we will figure out how we can make that more broadly available, because I know there were some people who weren't able to make it today. With that, thank you all so much. Thank you so much to our interpreter and our captioner. And thank you to everyone at DLC and beyond who worked on this. And thank you especially to everyone who came today. We really appreciate your participation. Take care, everyone.
Thank you.